Muri. Kejut.
Kita apa-apain. Wah,
Pakai yang mana? Okay. A'udzu billahi minasyaitonir rajim. Hello, Assalamualaikum. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera and very good morning. Inshallah, we will begin with Kitab Al-Fatihah.
Dia can buat sekali. Dia dengar kita kan.
Honored guests, respected speakers, and my dear brothers and sisters, on behalf of the organizer, the Management Services Division, I warmly welcome all of you to the session on legal matters pertaining to study leave, from privilege to penalty, legal implications of preaching study leave or fellowship agreements. Alhamdulillah, by the grace of Allah subhanahu wa ta'ala, we are gathered here this morning for a beneficial knowledge sharing session. We are deeply honored by the presence of our distinguished guests. Prof. Dr. Ahmad Faris Ismail, Deputy Director, Academic and Internationalization, IIUM, Madam Nur Hamsia, Director, Human Resource Development, Management Services Division, Mr. Jayananda Rao, and Ms. Gayatri Chandra Kasan from Mrs. Rao and Kamal. We also welcome all brothers and sisters, professors, doctors for joining us physically and via Zoom today. May this session be beneficial and counted as amal jariyah for all of us, inshallah. Brothers and sisters, it is my great honor to invite Yang Berbahagia Prof. Dato' Dr. Ahmad Faris Ismail, Deputy Director, Academic and Internationalization, IIUM, to deliver his opening remarks. Inshallah, Dr. Prof. Dr. the floor is yours.
Okay, thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all. Before that, I just want to check. According to the list here, we have about 69 or something participants online.
Have in Zoom and also YouTube.
Oh, YouTube also. So YouTube you cannot see that. Zoom. Siapa tu? Oh. Halo, siapa tu? Nak ambil email tu? Nak ambil tu. Siapa Muhammad Yusuf? Okay, so I hope that our colleagues, friends online can hear us clearly. Let us know if you have any problem so that we can fix it. We do not want to just talk to ourselves. It's problem when we are doing this. Sometimes we keep talking, and then suddenly half an hour, we have not. Yeah, you know what it is. They say, okay, yeah, all right, good. All right. Okay, so let me begin by, first of all, welcoming our resource person.
Thank you, sir.
And partner, Mr. Rao and Steve from Rao and Kamal, Advocates and Solicitors. And I have my colleagues here from MSD, Madam Norke and Madam Nick and their teams. Also Haikal from Legal Advisor. And most important is the participants, our staff, academic trainees, those who are currently on study leave or fellowship, or those who are about to begin your study leave, fellowship, as well as those who have completed their study leave but are still within the bonding period. So it's my pleasure to welcome all of you to this very important session. I am the chairman of SSLC, Scholarship Student Scholarship, Staff Scholarship and Study Leave Committee. Maybe this is the first time that we are having this session. As far as I can recall.
I'll watch for that.
Definitely. Yeah, we have been checking this at least as my capacity as Deputy Director for the last 6 years. But before that also I was the Dean. But I think this is the first time that we really engage our staff with our legal partner and legal advisor. As all of you know, study leave and postgraduate fellowship scheme, various schemes that we have are key privileges that IIUM provided for our staff, both academic and non-academic, as well as our academic trainees, whose terms and conditions of appointment require a PhD qualification for confirmation in service. So this is one of the uniqueness about this university, that it since in the 90s, not early 2000, the university has made it compulsory for all our academic staff at the various faculties to have PhD, and PhD becomes one of the requirements for confirmation in service. So throughout the years, eligible staff and academic trainees apply to study leave, fellowship upon joining IIUM, and of course, this provide valuable opportunities for professional development, advanced studies, and research, which ultimately contribute to the growth and reputation of IIUM. As a result of this policy, I think looking at all the public universities in Malaysia, IIUM always maintain a very good percentage of PhDs. I think maybe more than 90-something%. Okay. But of course, life always, we have challenges in life, no free gift. So all these privileges come with responsibilities. So I think I always quote the Spider-Man, with power comes great power, comes great responsibility.
Right.
So I think this is also true for our matter this morning. So a clear understanding, because of that, a clear understanding of the legal framework, obligations, and potential implications related to study leave fellowship is crucial to ensure compliance, prevent unintended breaches, and uphold the integrity of our study leave and fellowship programs. This session is particularly timely in view of recent legal cases that have highlighted the importance of adhering to study leave fellowship agreements and fulfilling the required bonding period. Today's session will guide us in navigating these legal matters, including the consequences of non-compliance and the best practices expected from all the participants. So I guess on behalf of the university, I would like to take this opportunity to express my appreciation to our guest and partner, Mr. Rao and the team, whose expertise in handling these matters at IIUM will provide invaluable insights. I hope that all participants will actively engage in the session, learn from the discussion, and apply the knowledge gained in fulfilling their responsibilities during and after their study leave and fellowship. So thank you very much. So I look forward for a fruitful session, and hopefully, this will avoid problems in the future. That is what we are. This is like our preempt and preventive. Okay, so that I think if we understand each other, then we can plan well, and we can also engage and at least discuss the matters before things get out of hand.
Right.
So thank you very much. I hand over back to you.
Thank you, sir. Thank you very much.
Thank you, Jazakumullahu khairan, Dr. Prof. Doctor, for those inspiring and meaningful words. Brothers and sisters, doctors, professors, we now proceed to the main session. It is my pleasure to introduce our distinguished speakers from Mrs. Rao and Kamal, the panel solicitors. Firstly, Mr. Jayananda Rao. Mr. Rao is the co-founder.
Berapa pun kalau RM8 contoh. So I expect lah. Contoh macam I nak bagi kat Faris lah contoh. So
Okay. Mr. Rao is the co-founder of the firm and a highly respected litigator with vast experience in criminal law, appellate advocacy, including capital punishment cases, administrative law, employment disputes, and white-collar crime. He has appeared at all levels of the Malaysian courts and served on the Malaysian Bar Criminal Law Committee and the Bar Council, IPCMC Task Force. He holds an LLB honours from University of London and was admitted as an advocate and solicitor in the High Court of Malaya. in 1995. The next speaker is also Ms. Gayatri Chandakasan. Ms. Gayatri has appeared in arbitration proceedings at AIAC under the SIPA 2012 Professional Inquiries and Statutory Appeals Boards. Her areas of practice include civil and commercial disputes, construction law, and arbitration. Ms. Gayatri graduated with an LLB honours from University of Malaya in 2007 as a Petronas scholar and was admitted as an advocate and solicitor in the High Court of Malaya in 2009. We are truly privileged to benefit from their experience and knowledge today for the session on legal matters pertaining to study leave. Mr. Rao, the floor is yours.
Thank you very much. A very good morning, Professor. Thank you very much for having us this morning, MSD friends. That's the best way I can call. It's always a pleasure coming to IIUM at any time. Always being greeted with a wonderful smile and good friendship. Now, thank you very much for having us. I do understand for the participants, the topic could be a little dry, this contract, but like what Professor said earlier, we need to know the boundaries, what the university is offering, and what the entire contract is all about. On my part, this morning, I will just breeze through the basic requirements of contract that many of you all need to know. And once I've gone through the basic preconditions or the applications of what contract is all about, I will give it to my colleague, my partner, Ms. Gayatri, to go into the crux of the matter, which is the subject matter of the agreements, contracts that parties have signed between university and themselves. Yeah. Very quickly, I think we have some slides as well. Very quickly, can I just look? Initially, most of us, I think every one of us have gone through contracts. It can be in our daily lives, that can be done by conduct. In fact, we conclude contracts by conduct every single day. All right, that is something that most of us don't realize. And we have this particular act of parliament called the Contracts Act 1950. If I could quickly look at one particular section which I think all of us need to be aware, that would be section 10.
Next slide.
Just a moment, please. Yeah, we're just kind of getting the screen reach. Okay, that is it. Right. Thank you very much. This section 10. This is the beginning of what the law says what a contract is. Right? Of course, they are all multiple wordings. Some of us can make sense of it. Some of us will think, what are they talking about? But bottom line is this. There must be this free consent between two parties in getting into a particular contract. All right. There must be some consideration and there must be a particular object. So in other words, there has to be an offer, there has to be an acceptance, there must be some consideration. All right. Now, what are these? They're very simple. Now, we are very familiar. Maybe this morning, somebody of you went to buy breakfast. Anywhere, all right? Shops, retail shops, mama shops, anywhere. Let's say for argument that we see goods displayed on the shelf. Right? Have you all ever thought, Who's making the offer? It's basic. We do it every day, but we don't think about it. All right? Who's making the offer? Are you making the offer, or the shop is making the offer? By explaining it. So now, I saw, let's say, donuts. Prof, we are buying donuts today.
All right.
I say, I buy one donut for myself, one donut for Prof. I go towards the counter, I'll take the tray, I will take the donut, I'll put it on my tray. What am I doing? Of course, you want to, you have not bought it yet, right? Where is the offer? Who's making the offer? The law says the display is an offer to purchase. Means that when I am taking it, I am offering to buy. When I go to the counter, the cashier has a choice to accept or not my offer to purchase. If she accepts, the intention to create a legal relationship has been sealed. There is a purchase. Simple as we read it every day. Yeah? Now I can tell you, sampailah kita hidup, you won't buy a donut, you start remembering the story. All right, who's making the offer? So here, the context, the law says, yes, Mr. Rao has taken the donut. He's going to see Mr. Haikal. I'm so sorry, Mr. Haikal, you're my cashier today. All right. I'm giving the donut to Mr. Haikal. Mr. Haikal says, all right, now I'll consider to accept it or not. Mr. Haikal says, sorry, sir, I can't sell you. There is no contract because he is refused to accept my offer. So there must be an offer, there must be an acceptance. What is the consideration? It's a donut. I want to eat. That is what the law of contract is. It creates a legal relationship between two parties. So that is how, from the example of a donut, that is how a contract is formed. We pass by supermarkets every day. We go to Mid Valley, we go to shopping complexes, you see display stuff everywhere. All right. That is only for the shopkeeper to give us an idea. Listen, I'm offering to sell something, you want to take it. So this is how the contract works. In very basic, simple terms, there must be an offer, there must be an acceptance. This concludes, it'll create a legal relationship. And there must be some considerations. What's consideration? The donut for the money and the money for the donut. That is how a contract is concluded. Simple terms. So, this is my conduct. Now, we have done so much in our lives that we have gone through these processes every single day that we do not realize it. We think contract is normally written. You don't have to be a written contract. It is actually by conduct. Most of the contracts are concluded every day. Conduct. You for petrol. Same thing. It's every single day you're concluding a contract, but you don't see it. So lay persons don't realize that they are getting themselves into a binding contract every single day of your lives. You can even go as far as going to a canteen today and buying something. You are having a contract. So contract is within our daily lives. Because most of us will be thinking a contract is something I put into paper, I sign, I don't have to. Now, even for example, when you pay, how do you pay? You pay using credit cards, cash. That is a form of consideration for you to conclude the contract. So, same thing here, when you have the power to buy something, the power to execute something, the law defines that you are entering into the contract. Under Malaysian law, you have the Contracts Act Section 10, which says that this is, don't go too detailed, it's very technical. It's very simple, offer, acceptance. Number three, there must be a consideration. If there's no consideration, there can't be a contract. You must have something. So that is contract. Now, let's take that simple principle and convert it to the topic of today. The topic of today is academic training agreements, fellowship agreements, etc. Now, this is written. Now, what I will do is that I will just give you basic understanding. We don't have to go too deep into it. We just need to have an understanding what this piece of document is. This piece of document is a legal document. Right? And whenever a particular document comes to question, ladies and gentlemen, there are this thing called the principles of contract. Right? What are the principles of contract that normally the court will look at? Court's view is very, very simple. There is party A, there is party B. Party A and party B entered into a particular contract. Let's say this contract, study leave fellowship agreement. First thing is that two people, like what we said, they have a freedom of mind to enter into the contract. Means that they are not forced. Each party is within their own comfort zone. I have this to give you. I want to accept it. So it's a question of law. In the sense that when you construct something, is it within the four corners of the law? It must be legal. Contracts can't be illegal. It has to be legal. Alright. Then, when you are writing the contract, the intentions must be within the four corners of the contract. You can't go out of the contract. You can't ask something which is not reasonable. Both parties, yes. You can't ask something more than what you give. They can't give you something more than what they promise. It must be within the four corners or four walls of the contract. It must be done from the date. Date is always important. That's what we always have contracts which are dated. Yeah. And very important, the court will always say, when I construe a contract, I will give meaning to it. And where does the meaning come from? From your terms and conditions, the offer and acceptance. What are the provisions of the contract? This is what gives life to contract. So, like I told you just now, it can be as simple as buying something from a display that gives life to a contract. Right? So the intentions are very important. All right. And we also have the issues of contracts. Some contracts are very simple, they can be half a page. Some contracts can go on pages after pages after pages. And I believe that any one of us who have done credit card agreements, hire purchase agreements, you have housing. How many of us have seen the fine print that you can't see? What is that? You are supposed to know. Then one fine day, you say, I don't agree to this, but you've already signed the fine print. That is the problem, because the court will look into the four corners of the contract. So it is very important that we understand the contract. But truth be told, we have been working as long as we have we are still blur about contracts. Because it is not one process that follows through and through. Courts have different mindsets. Courts have different understanding of contracts. I'll give you an example. We have this thing called the person who makes a contract must take a bigger share of responsibility. Means that you have the power to make the contract, right? It means that if there's any ambiguity, it will be against me. Example. Courts may look into that if there are certain circumstances that come around. Example. Alright, so court may say, hey, listen, why are you punishing that poor fellow who signed? You are an institution. But we will say, listen, even though we are institution, we are being fair. Everything is within the four walls of the contract. We never deviated. We never departed from the contract as it is. So very important that all parties know what they are signing and read it very carefully after or before you have signed the contract. Understand your legal obligations. Now, from what I have read, these contracts the last week, they're very straightforward. This is not commercial contracts where you are intending to make somebody work, somebody where there are certain clauses which are hidden in meaning, there are none. They're very straightforward. To me, looking at these contracts, they are actually for the recipient's betterment. Because these contracts are going to change their lives. In the sense that if I take it on, I can do better in life. But every contract, like we say, there is a consideration. The consideration is, what am I supposed to give back? So this is where we are going to say, as far as my contracts are concerned in IIUM, they are very straightforward. I am giving you, have something. You accept the offer. You're offering me something, I will accept, and you sign. You keep on the clauses, or you keep on to the what your obligations are, then you see it through. That is all. There is no, shall we say, anything cynical in the contracts. The contracts are very, very straightforward. So once the court has seen this contract, they are very clear. So the court will normally give very clear meaning to the contracts. They don't go beyond, they will not substitute, they will not put in new letters, new clauses. Court will not disturb the contract. The contract is as it is. And this contract is a live piece of document that has a lifespan. So until then, parties adhere within the four walls of the contract, then you are perfectly fine. Yeah. So sometimes wordings of the contract when we draft, the wordings may not come to light when they are contested down the road, 4, 5, 6 years later. That is where we need to know the contract is very fair in the sense that it is not couched in certain words or letters which will cause confusion. If it causes confusion, the court will interfere. They will make sure that that particular confusion is clarified. Now, I can give you an example. How many of us have gone to Putrajaya? All of us have gone to Putrajaya. Have you seen something very unique in Putrajaya? Belok kiri kalau tak ada kenderaan. Contoh kan. Can we do that in KL? Can't. Pelik. Alright. Putrajaya you boleh bilik diri. KL you can't. Kena saman. Why? That is what we call a specific provision overrides a general provision. Alright. So contracts are like that. They can be specific, can be general. So the law recognizes that in a particular situation, it allows you to do something that are specific clauses. But those specific clauses are mentioned in the contract. You don't fall back to general clauses. They don't have say to it. So that is how contract is alive. But generally coming, what the law will always say, the court will say is that, listen, you need to follow within the four walls of the contract. Give intention to it. And more importantly, you don't add, alter, or vary your contract. You have no say. The contract is as it is. Unless Ms. Gayatri will cover it later, parties agree that because of certain situations, political situation, legal situations, the law has changed, you can add on a contract by putting in an addendum. Just to say, listen, things have changed not within our control. Because the law now says something else. So to actually suit the requirement of that law, parties can come into an addendum that, listen, there is this clause originally in the contract. Now I'm going to come away with that particular clause because I have no choice. Things have changed, the law has changed, now both of us are bound by it. Now one person cannot come and say, I cannot, I don't want. You can't do that. Because you're not doing it purposely. Circumstances have changed. So that is the reason why the court is very, very careful that, listen, you just can't add, alter, or vary whatever contracts that you've signed. It must be within the four walls. So at the end of the day, it comes to what we call, when we do law, is a reasonable man's test. What a common man will think that when I get into this contract, what are my rights and liabilities? Can I execute? Can I keep to those rights and liabilities so that I can see through this contract? Now, once you have signed it, it's sealed and delivered. It means that you are bound by that contract, both parties. And that is a reason. Are absolutely clear. They are very fair. This is an offer here.
Kita ada kursus ni je, tak
Ah.
ada apa pun.
Boleh, Bang.
Kursus pun tak ada apa. Okey, okey.
Ya, Masih tahu.
Okey.
Okey, itu.
Excuse me, but we can't see the slides anymore.
Well, we'll be coming to it later, yeah, because what this is just that Contracts Act alone. Now, when this Gayatri picks it up, and then we'll go through the documents one by one.
All right, okay.
All right, thank you. Yeah, so coming back to the topic, before I complete my part of it, I'm coming to a tail end of it. It's just that these are the legal questionings when it comes to construction of contracts. It will be always on the principle of fairness, so that both parties know what they're getting to. So it will be absolutely beneficial, understand the terms and the obligations that you are signing. Question if you have to question before you sign, because there are also sureties attached in this particular contracts, because they too need to know what needs to be done. So on that, I think that I just given just a glossary of what the law of contract is. I'll revisit it again later once my colleague has completed. Now I'll just hand the reins to Ms. Gayatri to go through with the scholarship agreement as well as the fellowship agreements. Yeah, thank you very much. Thank you.
Thank you so much, Mr. Rao, and very good morning to everyone. My name is Gayatri, and I will be talking mainly on study leave and fellowship agreements. Can we go to slide number 5, please? As Mr. Rao had explained about the concept of contract, where there should be an offer and there should be an acceptance, and there are considerations under the contract. Now, taking that concept into our study leave and fellowship agreement. So to understand what is study leave and fellowship agreement, this is basically a legally binding contract between an employer and an employee, or a prospective employer and a prospective employee, outlining the terms of agreement. Now, I understand that most of y'all are actually academic trainees or academic lecturers, and trainee lecturers, as well as administrative staffs, lecturers. So there are two different category of participants today. Some of y'all are staffs of IIUM, and some of y'all are not staffs yet. So that's why y'all are known as lecturer training or academic training. Now, what is basically study leave and fellowship agreement? This is basically IIUM giving you the study leave for staffs. Only staffs are entitled for study leave. So they are offering study leave for the staff to pursue a course of higher studies, and they are offering financial support throughout your study period. Now, what is the consideration? Once you have completed the course, you're supposed to come back to IIUM, report to work, and have a bondage period. Similarly, for academic trainees, you are not a staff yet. So, but they have identified y'all as the prospective employees. And in order for them to employ you, you must have the qualifications. So what they do is they send you for higher studies. They give you allowance throughout the period. You are supposed to complete it and come back, report to work. If there is a placement for you available at that point of time, IIUM will offer you a job and you are supposed to have a bondage period. So that's basically what is study leave and fellowship agreement as far as IIUM is concerned. Study leave is given to staffs and fellowship agreements are granted to academic trainees and non-staffs. So at slide number 6, I have put down the differences between a study leave and a fellowship agreement. Like what I have stated earlier, study leave agreement is an agreement between employer and existing employees, wherein the employer grants study leave with or without salaries and allowances to enable the employee to pursue his or her higher studies. And these employees are required to report to work as soon as they have completed the study leave. Employers is and will continue to be in employment and has obligations towards the employer as any other employees unless stated otherwise. What is meant here is, even though you are on study leave, it doesn't mean that you are out of your obligations towards IIUM. Whatever obligations you have towards your company will still remain. Unless the company says, okay, you don't have to do this particular work. You don't have to do certain, you're not obligated to come back to work for, X period of time. Then, yes, you are not obligated. But otherwise, all your obligations as you were working still remains when you are on study. Meaning you cannot go and work elsewhere now. You cannot get employment any other places. You're still an employee of IIM. Whereas for fellowship agreement, this is like what I said earlier, is between universities and the academic training or the lecturer training, where the university picks up these potential employees. They give them salaries, they give them allowances. Sorry, not salaries. They give them a scholarship, they give them allowances for tuition fee, whichever is applicable. And that would be stated in your agreement to enable you to pursue higher studies. And you are supposed to report to the university upon completing your fellowship. And after successful completion of the course, the university has the right to accept you as an employee, provided there is a placement in the environment. Now, as all of y'all would have signed either the study leave agreement or the fellowship agreements by now, I'm sure. And if you notice in your agreements, these are the salient terms which you need to look out for. One, your study leave period or your fellowship period, which was granted by the university to you. If the university has granted you 2 years of study leave, it means you need to complete your course within the 2 years. So you need to make sure that your study leave, which has been granted by the university, is sufficient for you to complete your course. There is no point you completing the study leave, but then you don't have your degree. That is not, it means that you have not fulfilled your obligation under the contract. So you need to make sure that your study leave period is sufficient to cover your course itself. Number 2 is the course details. You need to make sure that your course details, your commencement date and your completion date are all stated in the agreement. This is important, like what I said, your study leave has to be sufficient to cover your course details. You cannot come later, you can ask for 6 months study leave. And then you come back later to say that, but I'm doing my PhD, I need 4 years. 6 months is insufficient for me. It's too late once you have signed the agreement. Because when you sign the agreement, you have agreed that you will complete it within the 6 months. So by hook or by crook, you need to complete your studies within that period granted by the university. I'm just saying 6 months because, just for example. But in reality, university will always give you study leave in line with your course period. Unless you need extension, then there will be a term where you can ask for extension. So you need to comply with all the regulations as far as extensions are concerned. The third one is your sureties. Now, a lot of people take it for granted that, I just have to give 2 people's name and that's okay. You all need to understand that your sureties also have the same obligation as you. In fact, they are in a worse position than you because they don't have the benefit of receiving the allowances or the salaries from the university. Yet, if you have breached the agreement, they too are liable to pay whatever that the university has incurred by paying or expending on you throughout your study period. So it's very important that when you select your sureties, of course, I think the requirement is that you bring in 1 family member as a surety. But that family member also have to have should be gainfully employed. And is able, the reason why is because if there's any breach, this surety should be in a position that they are able to pay back to the university what the university is claiming. So it's very important that sureties also must know what they are signing. They can't just blindly sign because of you. They should read the
Emergency kan? Setakat ni tak ada lagi.
just for a point to be taken, whoever is just coming into our session right now, please mute yourself so that you can hear the session better. Okay, where was I? Yes. Okay, so it's very important that sureties must know their obligations under the agreement. Because what they fail to notice is they will just say that, okay, my son or my daughter is going for studies and I just have to sign the agreement. No, they should know that what they are basically coming to university to say is that I guarantee that this person will complete the studies within the period and will work with you throughout the bondage period. That is the guarantee that they are giving to the university. So it's very important for them to know their obligations as well. The fourth one is the obligation of parties under the agreement. I will be mainly talking about the obligation of the academic training or the stars, which I will tell you later. But every party needs to know what are their obligations under the agreement. And the fifth one that you need to know is the type of scholarship or sponsorship that you are being awarded by the university. And what are the offer given by the university under the agreement? Because some staffs will get certain allowances which are not given to the academic training. So you cannot come back and say that, oh, how come they are getting EPF? How come they are getting so? I'm not getting it. The reason why, because you're not a staff yet. So you're not entitled to be given certain allowances as what staffs are getting. So you need to make sure what are the sponsorship that the university is giving, what are offers given by the university, which are all stated in the agreement. The most important thing, you also need to know your compulsory employment period. Now, this compulsory employment period starts from the time you successfully complete your studies and report to work. So from there, the bondage period starts. So you need to make sure when you complete, don't forget that you also need to come and report to work. Don't just take 1 month, 2 months off and say that, okay, I can come back to work later. I can report to university later. It doesn't work that way. Because the agreement is very clear. Once you have completed your course, you have to immediately come back and report to work. You also need to know what constitutes breach under the agreement. And also what are the consequences of a said breach. Now, all these I will cover in the later session. So we move on to the main obligation of staffs or the academic training under their respective agreements. Now, you have two main obligations. You may have your agreements, you will notice there's a lot of pages to it. But you need to remember there are two main obligations that you have under the agreement. One is to diligently undergo the course and complete the course to the satisfaction of the university within the study leave or fellowship period or within any extension of time granted by the university. Now, as I have stated earlier, the university in the agreement, they will only say the course period is for 4 years, for example. They may say the course period is 4 years. Now, your obligation is to complete it within 4 years. In the event you know that you cannot complete it within 4 years, say 3.5 years, you know already, I can't finish in the next 6 months, I can't finish my studies. I need extension. Look into the agreement and see how long notice do you need to give to the university for you to make the extension application. You need to make that application. In most cases, it can go up to 6 months, sometimes it's 3 months. The reason why the university asks for this time frame to put the application is because your application for extension of time need to undergo a lot of stages. They need to put it to your supervisor, they need to go to the dean, they need to go to the higher management, and a meeting has to be set up for the management to go through your application and see whether they can grant extension of time or not. So it's very important because previously we have cases where the staffs take it for granted that I can just get extension of time as of right. It's not as of right. Extension of time is not given to you as of right. It's given only if university feels I can afford to give this person extension of time. Now, just because they gave you the first extension of time or the second extension of time, again, you cannot take it for granted that every time I put in my application, the university is going to grant it. Why? Because 2 times I've applied, 2 times university have granted it. It doesn't work that way either. Because the university also have their KPIs. Why? When they send you for higher studies, the university is not simply sending you because, they just want to offer anyone scholarship. No. In their plan, they have a long-term plan, which probably in 5 years' time, Mr. A will come back and serve my university. Now, if you don't comply, when you keep on asking for extension of time, sometimes don't be surprised, there are people who have asked extension of time more than their course period. We have cases in that way, in such cases also, where they have asked more extension of time. Just say the course is for 4 years, they have asked for, they couldn't even complete even after being given another 4 years or 5 years of extension. And when they come to court, their reason is, oh, university has given me extension of time, so I take it for granted that they will keep on giving me as long as I apply for it. It doesn't work that way because the university would have, when they put you for a course, they would have had a plan that this person will come back and serve me in 5 years. In 5 years, 20% of my staffs are going to retire. Now, these people will come and fill in that placement. Now, because of your act of asking for extensions over and over, what happens when they really needed the staff? The staff is not there. Their earlier staffs have retired or resigned, but they can't get new staffs because you have not fulfilled your obligation by completing the course within the time frame given. So you need to know, even with extension of time, that extension of time is also a privilege. And you will notice, those who have asked for extension of time, you will notice that only for probably the first 2 extensions, or maybe a 3rd extension, will be given with allowance. The 4th time onwards, they won't give you any allowance. 3rd onwards, 3rd onwards, they don't give you with allowance. That shows how serious they are, because they cannot simply keep on giving you extension of time with salaries and with allowances. So you need to use your time given to you to complete the course successfully and report to work. The second one, the main obligation that you have is, once you have completed the course within the time given to you, you have to report to the university and complete your bondage period as a. Some of you may have 4 years bondage, some of you may have 5 years bondage, some of you may have 6 years bondage. Now, you cannot complain, why is Mr. A given 4 years, but I have to work for 6 years? That is because your course that they have offered you is probably a specialized course that not many people would have taken that course. So which is why they probably needed you to be bonded with them for a longer period. The investment on you is probably higher than what the university would have invested on studying. So all this comes into play. It doesn't mean that they are being unfair to you. as compared to Mr. A. It's just because what they have invested in you is more than what they have invested on Mr. A. Now, let's move on to issue of breach of study leave or fellowship agreement. Now, in our past cases that we have handled, what we see is staffs or academic trainees are likely to commit one of these two main breaches. One is they fail to complete the course within the study leave or within the fellowship period. These will warrant a breach under the agreement. And two, they completed, they report to work, but they fail to complete the bondage period, meaning they resign before completing their bondage period. That also constitutes a breach of the fellowship agreement. Now, the first issue, failure to complete the course within the agreement period. Now, it's very, very important, like what I told you earlier, you must complete the course within the time given to you. And if you know that you cannot complete it, it's also very important for you to see the clauses on the extension of time, to know when is the last period where you can apply for your extension of time. Don't take it for granted that, okay, I have 4 years course, I cannot complete it without 4 years. Never mind, I will keep quiet until IMUM asks me. You cannot do that. That is considered as a breach under the study leave agreement. And the university has the right to terminate the agreement. So you, as a person who's receiving the consideration under the study leave agreement, under the fellowship agreement, it's your obligation to make that application for extension of time within the specified time stated in your agreement. The university will then consider whether extension of time applied, whether can they grant it or not. And they also have the right to reject it. Now, what happens if they reject it? It means you have breached your obligation under the agreement because you could not complete your course within the time granted by the university. And if you are not granted the extension of time and you are not able to complete the course, or if the extension of time is given to you, yet you cannot complete the studies within the extension of time granted to you, both the situation will constitute a breach under the agreement. And there's also another clause. If you quit from the course, this has also happened during the course period. They have quit halfway, saying that I don't want this course. These two constitutes a breach under the agreement. Because your obligation, like I told you earlier, you must diligently undergo the course and complete it successfully. So if you quit halfway, it's also considered a breach. Now, second failure. This time, you have completed your course, you have reported to work. And this is where the bondage period starts. The university will usually take into account your date of reporting to work as the date that you have commenced your employment, and the bondage period of just say 4 years, 5 years, 6 years starts from the date you have reported to work. So there are differences in it because sometimes the commencement of bondage period is calculated from the date you are conferred with the degree. Because sometimes when you have completed, you know you have finished your course, but you're not given a degree yet. You're not conferred with a degree yet. So that means your bondage period has not started. There are times where the university will just say, okay, it doesn't matter. I know this person has completed, she has reported to work, she will be conferred with a degree in maybe 2 or 3 months' time. But I will take it from the time she reported to work, not the date she been conferred with a degree. So it can work in both ways. In any event, your agreement will say when the bondage period starts. So you also need to make a point to check your agreement on the commencement of your bondage point. Again, like what I said, if you have worked, you have started your employment and the bondage period commences, if you resign or you are terminated from the university for any reasons whatsoever before the bondage period ends, that too will constitute a breach under the agreement. Now, what happens due to the breach? Or what are the consequences of the breach? Again, your agreement will state these consequences. In the event a staff or an academic trainee fail to complete the course within the time granted, or if they quit before completion, or if they fail to complete the bondage period, the university has the right to terminate the study leave or fellowship agreement and claim the following. 1, they can claim for the expenses incurred under the agreement, meaning whatever they have paid for you. If you are studying overseas, including your placement, your air tickets, whatever they have incurred, they can claim. Number 2, they can claim whatever agreed sum, if the sum has been specified in the agreement. Certain agreements will say, if you breach, regardless of how much we pay, how much we have expended, there is this penalty clause of 120,000 or 150,000. You need to pay me this amount. And if you have agreed, you must pay that amount. If you are a staff and you have breached the agreement, the university also have the right to terminate your employment. If that termination has been stated in the agreement. So as staff members, and also as academic trainees, you must make sure what are your consequences of the breach, so that you know how important it is to comply with your agreement. Now, the university's reasoning in claiming for damages or order for breach, like what I had stated earlier. When a staff is allowed to pursue a course with pay, this is given because the university's consideration is that these particular staff or these academic trainee will complete the course successfully and return to serve the university for a specified period of time. And when you fail to deliver your side of the obligation, the university would lose out in terms of monies and time spent for you during the course period. And now, because you quit halfway, or because you breached your agreement and the agreement has to be terminated, the university now has to find another prospective member, ask them to go for study leave agreement or fellowship agreement, spend more money for this person. So what they have spent on you, now they would have to spend on the second person, but they're still not getting what they want, which is a qualified staff. So that's the reason why they have to put in this clause to claim for damages. So that academic trainees or staffs who go for study leave do not just take it for granted. It's not your right. It's a privilege given to you so that you study without any problem, without any financial restraint, you can come back to serve the university. So here's the reason why we are saying if when the university fail to get their part of the bargain under the agreement, it's only fair that they are reimbursed on the monies that they have spent on the staffs or the academic trainees throughout the course. Now, what happens when the study leave or the fellowship agreement is terminated? So the university don't just stop at terminating it. They will also demand the monies that they have spent. Like what I said, they have 3 ways of claiming. They can claim the monies that they have spent on you. They can also claim for a specified sum if it's stated in the agreement. They can also terminate employment. So under the fellowship or the study leave agreement, once they have terminated, they will demand that this sum of money are paid to the university so that you can put the university back to its position before. So in this way, you and your sureties, like what I said earlier, your sureties, this is where their liability comes in. You and your sureties are liable to settle the said sums upon the demand of the university. And if you don't settle the sum, what happens? The university has the right to pursue legal actions against you to claim the said sum. So that's when you will have to go to court to fight your case. And this brings us to our next topic, which is civil suits and its consequences. What happens when the university decides to claim for their money against you in court? The university has, like what I said, when they demand money and you do not pay for it, what happens? They can go to court. Now, if the money that they claim from you is less than 100,000, the case will be filed in magistrate court. If it's more than 100,000 but less than 1 million, the claim will be filed in sessions court. And if anything more than 1 million, the claim will be filed at the High Court. So not only you, but it's also your sureties who will have to come to the court to fight their case. Now, what happens in court? This is proceedings in court. Once the case is filed in court, if you want to fight, you have to appoint your own lawyers. They will come to court, both sides will argue, you need to give evidence, the university will give their evidence. At the end of the day, the court will make a determination of whether you are liable to pay or not. And let me tell you, in most cases, because the contract is very clear, the court will say, yes, the staff has to pay. Staff, not only staff, the sureties is also liable to pay. Now, at that point in time, you are not only paying what the university had claimed earlier, you also have to pay cost, you also have to pay interest. And not to forget the legal fees that you pay to your own lawyers. So, if the court is satisfied that you have breached the agreement, and you are liable to settle the said sum, the court will order you and your sureties to jointly and or severally pay the judgment sum together with the cost and interest to the university, within a specified time. If you fail to pay within the time frame, what happens? University has the right to proceed with execution process, including making you a bankrupt, freezing your bank account, seizing your assets, etc. So it's not as simple as like what I said earlier. I can't finish my course, doesn't matter. I will later I can just put in my appeal to the university. University will just consider it. No, don't take it for granted. The university has the right under the agreement. They can go all the way to court to claim for their monies, whatever they have, whatever you have agreed to pay under the agreement. So it's very, very important as staff members, as academic trainees who have been chosen to undergo courses to comply with the terms of the agreement, mainly where it concerns your obligation, that is completing the course successfully and completing your bondage period, as you have agreed. In the event you fail to comply with these terms, these are two terms that the university is asking for. Complete your studies within the time frame given, complete your bondage period within the time frame given. If you fail to do so, these would cause losses to the university. And that is the reason why the university has no choice but to terminate the agreement. And once the termination happens, you and your sureties have to settle the sums expended by the university, failing which you need to face the court cases. So that is basically covers the gist of the study leave and the fellowship agreements, what are your obligations, what constitutes breach, and what are the consequences of the breach. Now I give it back to Mr. Rao if there's he wants to add on.
Yes, thank you, Gayatri. Thank you very much. Ladies and gentlemen, I won't take much of your time. Gayatri has given a very illusory narrative of what your responsibilities are. Now, if you were to look generally at the contracts that you have signed or going to sign or are looking into, they're only about 20 odd pages all in all. They're not complex. But throughout the talk that Ms. Gayatri has provided, I think that one particular word that had come before would be a privilege. Means that anyone signing these particular agreements, in my view, subjectively, is in a privileged position to serve the university, to upend your life for better. The offer is in the 28 odd pages. Read them carefully. We are paying you. We are sustaining you. All in written that the university is asking within their legal parameters is to complete within the specific time that you have undertaken to complete, serve the bond period, and it is only going to enhance your lives in the future. My always avoid litigation. It is messy. It won't end up. No party here is a winning party. Like what Ms. Gayatri said, the protocol, the consideration, the processes that university have to face. You, by assuming argumentatively, if there is any breaches, you have deprived another candidate of his right, who could have seen through this without any hiccups. So at the end of the day, it's purely fair play. And at the end of the day, it's just for you to see through the entire undertaking that you have undertaken to its completion. And at the end of the day, both parties will be living happily ever after. Yeah. So I don't see any issues personally, but of course, the university is always there to hear you in the sense of, listen, if I have a query, what can I do? Listen, life is not determinative. There is no guarantees. Things may change, but don't reach the limits. That's all I'm asking. Yeah. I think that on part of Ms. Gayatri and I, we have wrapped up on our part. I think there will be a question session later as well. All right, and then I will leave it to the floor to Haikal and Paul. And thank you very much for having us. If there's anything that we will be able to assist later, we'll be more than happy to. And thank you very much again. Thank you.
Thank you very much.
Thank you.
Alhamdulillah. Thank you very much, Mr. Rao and Ms. Gayatri, for the very enlightening session. Brothers and sisters, doctors and professors, we will now open the floor for question and answers, our Q&A session. Just a little bit of ground rules lah. Just remember, kindly introduce yourself, your name, your kuliah, your current level of study, and before posing your question, and kindly let everyone know to whom your question is directed to, either to Mr. Rao or Ms. Gayatri or our speakers lah. Okay, the floor is open. And if let's say if you want to put your questions in the chat, there's also okay lah for everyone who is in the Zoom meeting.
Yes, originally.
Okay, the question in person, anyone?
Can you also check YouTube?
Ada chat? Ada any question on the chat?
Ada. Kami buka kami check.
Somebody just speak. Dia nak boleh.
Hi, can I ask a question?
Alright, can you introduce yourself?
Okay, Assalamualaikum and a very good morning. I'm Dr. Aida. I'm from Kuliah of Medicine. I'm currently undergoing, this might be confusing. I am a staff, but I'm undergoing fellowship. But I think the not scholarship, the cuti saya dapat is not fellowship as your definition lah, Mr. Rao and Ms. Gayatri. Because your fellowship definition is non-staff or an academic trainee, right?
Yes.
But I am a staff and I'm doing fellowship, but it's not a fellowship punya ni lah. But anyway, my question is, once you have signed the agreement, can you change it if agreed upon?
Yes, you have the right. That means both parties have to agree. You can vary the agreement, or you can put in an addendum to it. So, but you must, both parties need to agree to it. You need to make an application to the university, just say you want to change your course. So you put in an application to university, the university will determine, will table your proposal in a meeting, and then the management will decide, and then they will let you know whether they allow it or not.
Good morning, Dr. Aida.
Morning.
Doctor, when you say can vary the agreement, may we know what variation are you looking at?
Okay, so I initially applied for a part-time study leave, and then I reconverted. I request, even before we signed it, I request a change to full-time. So I want to know whether I can request back to part-time because of certain things that happened. For example, I wanted a full-time study leave because I was planning to go to the US as part of the attachment. However, the conditions in US, what's going on politically has made me change my mind not to go there. So then I want to know whether I can change back to part-time.
All right.
Does the university also allow? I mean, legally you say this can be done. Prof. Haris, boleh ke Prof. Haris?
I guess like what Mr. Rao mentioned, you can always submit whatever that you propose, and then it will be brought to a committee that we will look into it and discuss the matter. So we need to see the detail, and
Yes.
and I'm very sure the secretary also must do some calculation and all this.
Because by
Yeah.
going for part-time again, it means that you may take longer period to complete the course. So the university will have to see whether if a longer period is given to you, would it be viable for them? Would they have a placement when you come back and all that? So for that, you can put in an application. No one can stop you from putting an application. You can put in an application, but at the end of the day, the university has to see whether your application is viable for them. They will sit down, table it, and they will decide. If they can, then they will give you, you can make variation in the agreement.
Dr. Aida, also the other thing, just on the legality of what you have posed this morning. Every contract, there is a structure. And like we said, there are terms, offer, acceptance, consideration, etc. As long as whatever that you're seeking to vary doesn't change the structure of that particular contractual obligation between parties, then the answer would be yes. But when I say yes, there is a caveat attached. It doesn't mean that it will be allowed, but again, like Professor said, there are mechanisms that we have to go through. So I don't see a problem. Legally, I don't see, as long as the structure is not changed, it is still a scholarship agreement, fellowship agreement is within those ambit of the document, then yes, you may apply for variation pending approval from the higher authorities and management. That would be a better way to go through.
Okay, crystal clear. Thank you.
Most welcome, Doctor. And wish you all the very best.
Thanks.
Alright, any other questions from the floor? It will be better if we ask the questions via your video.
I didn't check the agenda they have.
Then we'll go to the questions in the chat. So this question is from Sister Nurul Shafiqah. May I know what are the implications if report to the university a few months late after completing studies with no intention to breach the contract? Sister Nurul Shafiqah, may I know this question is directed to which speaker? Okay. If not, in general, I think
Can
okay.
you take it up?
Yeah, excuse me. Okay, like I stated earlier, your obligation under the agreement is specified clearly. If the clause particularly says you are to report to work immediately after completing the course. So that means immediately you have to report back to university. If you want, just say you need time, you need to apply for it. Because if you take it for granted, I can come back a few months later, I want to take a break. You know, this whole course has been giving me, nightmare, it's so stressful. I need a 2 months break. And you take it for granted that you can do it without informing the university, that would be considered as a breach in the contract. So you must make sure that you inform the university in the event you want to report to work later. Only if the university allows you to report to work later, then you can do it. Without the approval of the university, you cannot report to work much later than what you are required to.
But we'll take it from there as well, but I mean just a food for thought. This is what we call a structure of responsibility. Don't take it for granted. That is all we can advise you. That listen, I have completed. Now I want to take a break. I will commence when I think I'm prepared. Try not to do that, because it may cause unnecessary infringements onto the contract. So the best would be clarify, see in person or write, listen, how soon can I start if you're uncertain? But like Ms. Gayatri has mentioned, you have to do the continuation as soon as you have completed. That is the precondition. So it is quite kind of what we call that it's semantics, come to think of it, but you have to do it ASAP. Don't take it for granted that you got time.
Thank you so much. And the next question is from Brother Muhammad Azamin Anwar. Dr. Azamin from Kuliah of Medicine. What Islamic principles are or were used in the contract to make it Sharia compliant agreement? I think this question should be related to.
Yeah, I'm standing with my hands up because I really have no idea.
There's no interest that is.
Yeah.
As much as there's no interest in the contract,
Yeah.
in the trade sum.
I guess maybe we can flip this question. And as long as I think, first of all, of course, I mean, as long as there is in the contract, there is nothing contradict Islamic principle, then I think the contract can be considered valid. Okay, but of course, we also have our legal people from our faculty of law. Your legal advisor is from faculty of law. Okay, so I think we will take this note and I mean just make sure that you the legal office.
Then I'll give a little bit input from the office of the legal advisor. First and foremost, the contract itself is drafted in the sense of it's more of there's no interest as per Ms. Gayatri mentioned, there's no interest imposed lah. If you were to go to get any conventional loan in any financial institution, there'll be interest imposed. But it's inside all the study leave agreements and all the fellowship agreements, there are no interest imposed. In fact, what the amount paid, and that is the amount, is the claim sum lah in any cases lah. And secondly, I think it fulfills all the Islamic concepts of contract, the ijab, the qabul. As far as we're concerned, that we also periodically review the contracts to make sure that it's Sharia compliant too lah. So I think that answers the questions from Dr. Azamin.
But just to add on from what Brother Haikal said, don't get confused with the interest from the court.
Yeah.
Okay, what the court awards, any cases which is filed in the court of law, the winning parties are entitled for interest on the judgment sum. That is not something that parties can say, I don't want the interest. Parties cannot say that. So that interest is awarded by the court. So don't get confused with the interest that yes, the loan interest and the court interest.
Okay, for the next question is from a very long question, Muhammad Badri from Kuliah of Pharmacy. But put it simply, let's see here. In situations where these factors significantly affect completion, which involve personal sacrifice, mental, emotional health challenges, how does the university balance both its institutional investment and the well-being of staff member when handling such cases? I think this question is in regard to staff mental, emotional health challenges.
Who is the questions from pharmacy? Alright. Good morning, Chair Muhammad Badri. Alright, I do understand the impact of the question. Like Brother Haikal said that it is issue of well-being. Now, first, we can look at different concepts. Alright. Number one, like we said, there is offer and acceptance. in the sense that one has undertaken to better themselves and gone into this particular challenge of upgrading one's life and to undertake this particular contract. Now, every single environment comes with its own mental, emotional, and health challenges. That is given. Insofar as the university is concerned, throughout the entire process of undertaking this contract, I don't think so there is any oppression, there is no any suppression, there's none. It is up to the candidate to fulfill the requirements under the four walls of a contract. Right. Now, I believe very personally, please correct me if I'm wrong and I stand corrected. Yeah. The institutional investment here is for you to give back what was given to you. And there is no any compulsory requirement on the university to ensure the well-being of the candidate when they undertake this particular obligation. So here, what will happen is that whether the candidate is ready to undertake this arduous task for their own betterment and to complete the studies within the period. And that is the very reason why, as far as the university is concerned, there are many considerations given throughout the process. So we can't come to your aid and say, listen, are you okay handling this? You have put your foot in, you have to see it through. Now, if you are unable to complete within a period of time with good reasons, the university will consider extension. Example. There are many other areas that university can come to your aid to see through that everything is done so that parties will fulfill their obligations. But unforeseen circumstances like global events, supervisor-related issue, trying to complete, the university will endeavor to assist in any way whatsoever, because that is a commonality in this particular agreement. Yeah. But to ask the university to take an additional step, all right, that the well-being of the staff member, I think that would be case-to-case basis. That would be better handled that way, case-to-case basis, to see what is the staff going through upon request. So on that score, if both of us know our own jurisdiction, I think we can work hand in glove to complete the task which each has endeavored to complete. That is my take.
Yeah, if I can just support or add what Mr. Rao mentioned, because we do have few cases that we discuss. So exactly what like Prof. Rao mentioned, number one is case to case. We cannot generalize this.
Yes.
And then number two is my advice as an older brother is if you foresee these problems, don't wait until the very last moment, because normally when it reaches us, it's already, cannot be. Yeah. So it's possible. I mean, even in the second year, you already sense this. Then you start to engage, discuss. Then there is a better chance for us to have good resolution.
Yes.
Because normally when it comes towards the end, then we have to go to the agreement and say that
Right. Yes.
your time is already expired. I mean, those are the things that my advice happens. So we need to say that yes, there is always the human value there, but you need to also inform the university as soon as possible. Don't wait until very late, and this thing will be discussed in a case by case manner. I mean, for that matter, I mean, if let's say you tell us very early, we say that don't continue, come back. I mean, those are the things that we need to engage. Yeah.
Right. Thank you so much, Professor. Next question. I think we already addressed this question. Okay,
Sorry. Assalamualaikum. I'm Dr. Rashida. I'm from Kuliah of Medicine. I think I need to raise this question because it's pertaining to the question that has just been answered, if that's okay. So pertaining the question earlier, it talked about unforeseen circumstances, but as we get older, I think the issue we need to think about death. Actually, when I signed the agreement, I was thinking about my family. What happened to my sureties and my family if I, in due course of completing the study or probably completing the bond, what happened if I passed away? So probably Datuk can enlighten us on that. We don't want to, of course, we want to improve our life, but we don't want to leave our families behind with the burden just because we want to further on our lives. Yeah.
Maybe before the legal people talk, just talking about from our experience. Again, in this matter, according to the agreement, of course, the person who signed plus the sureties, of course. I mean, wherever that is breached, then the sureties will take over. But again, I think in this situation also, where I mean, in the bondage period, the staff pass away, for example. I think the university has, again, case by case consideration. I think we are going to look at the whole thing. For example, I can give you this exaggeration. I mean, suppose that we say that, wow, this staff have a 10 million estate. So maybe you can say that, I mean, we can claim, right? But if they say that, wow, the staff has still children going to school, blah, blah, blah. So there is a lot of consideration on this issue. I think we normally side with the staff welfare and I mean, to facilitate their family and not to burden the family. And that is but we cannot say now, no, the loan will be forgiven. No, we cannot say that now. So it again depends on the situation, case by case, and so I hope that will at least calm down your side. I mean, not to be so worried. So just now get your complete your task and try to contribute as much, and I think we'll cross the bridge of when we are.
Yes.
Okay, thank you.
Thank you, Datuk. Correct. Thank you.
Okay, so the next question is, I would like to seek clarification. This is from Brother Irfan Salmi. I would like to seek clarification regarding my bond obligation. I currently have 5 years remaining under my master's training bond, and I am now undergoing fellowship training, which carries a 6-year bond. May I know whether these bond periods run concurrently or separately? Okay. So, is there
Yes. Your fellowship agreement will actually say your bond period under the fellowship agreement will only start after you have completed any other bond which you have or any other agreements that you have signed earlier. So in this way, it's not concurrent. It's after you basically, if you're saying there's 5 years under masters and 6 years under fellowship, then it's 11 years in total. So it will start from the time you have completed your fellowship training. They will see if you had done any, whether you have reported to work during your masters. After completing your masters, they will also take into account that period of time before you go for your fellowship, and then they will calculate your 11 years. It has to be separately.
Okay, thank you, Ms. Gayatri. So next question is from Sister Rika Rahman Asaldin. Is it possible for us to know the total amount of compensation without the need to tender our job first? I think this is tender for resignation. This is important when we are in dilemma, because when making decision about future life and career, especially when something unexpected things happen during our employment.
Can they get estimate first of all? They want to get estimate. If they leave a job, how much they have to pay?
Okay, that is also subjective actually. It depends on the duration and also.
Dia nak estimate. Namanya boleh tak, for example, they come to your office and say that I'm going to resign. I have 3 more years to go. Can you give us roughly how much I have to pay?
Boleh,
Can,
yeah, sure, we can count.
You can ask lah. I mean, if you need to know estimate, I think they can do some calculation lah.
I think I believe many has been asking.
Because this matter is sometimes ada nak buy out you out for everything kan. So the key is communication lah.
Very true. I think there's more dialogue. Just have a dialogue because it's a win-win situation at the end of the day. That's all.
Alright, so let's see. No other questions. Is there any other questions on the floor? Anything? Alright.
Sorry, Galvin here from Kuliah of Dentistry. Sorry, I have a question. Is it possible to ask just one question? So for example, based on the contract, the given time frame for me to complete my studies is 36 months. So let's say my program actually will finish, my program finish in 35 months, and I only get my certificate by the 36th month. In that case, can I go back at the 36th month, or I need to go back at the 35 months?
Very
Because when I read through the regulation, it stated that we need to go back and report duty once we conferred the degree. So I'm not very clear about that terms.
Galvin, sorry, Rao here, Galvin. Can you run past me one more time because I failed my maths? So can you just,
Okay.
So you're saying that you've gotten your degree
1 month earlier.
Yeah, 1 month earlier.
months, but he gets his degree only on the 36th month, a month later. But
once-
which is within the study leave period. Does he need to come on the 35th month itself?
Okay.
What to work?
Okay, this is Galvin, this is something which I would like to inform you.
Mhm,
We call this a lacuna in the legal term.
mhm.
All right, there is a unknown certainty or uncertainty. Right now, it says that upon you obtaining your degree, completing your course, you have to report. Right, that is what your contract says, and you're saying that you have gotten a degree earlier,
He has completed it on the 35th.
35th degree.
But without degree.
But he doesn't have that degree on hand.
A degree.
His probably graduation is probably another 1
Yeah.
year.
Okay, I would say the best way, why don't you come forth and clarify? So
Okay.
that you have put forth your squabbles, so to say, I have this issue. Can you come back with me for an answer so that
Mhm.
I will be abiding and I will not be breaching anything?
Yep.
Okay, that would be a better thing because as opposed to making a decision on your own or first make a decision and there could be some form of infringement that may be detrimental.
Yeah.
So I would say that better address the issue in writing or in person.
Yeah.
And at least you have channeled your issue to the other party and they may kind of return with an amicable answer that which is a win-win for both.
All right, sure. Okay, thank you so much for the explanation.
You're most welcome.
Thank you so much. Alright, do we have any other questions? Okay, this is from Dr. Zainan. I am Dr. Zainan from SUSMEC. My question is about the penalty and the total amount to pay if, in case of termination of compulsory service. Do the university consider take into consideration the years of service that we have served when calculating the compensation amount? When unexpected things happen, especially when there is conflict of interest in between the specialist SUSMEC and Kuliah of Medicine, I might take into consideration for early termination of the contract. So, Dr. Zainal, so this question is directed to Mr. Rao, Ms. Gayatri, to Professor.
Early termination, better.
Okay, for early termination, the agreement does not say that the universities have to take into account the years of service. It just says if you have breached, in the sense that you have not completed your bondage period, then whatever they have spent on you during your study period, you have to waive it. However, I also know that there are cases where the university have also taken into account years of service, but that is purely the university's discretion. So if they think that yes, I can give some leeway by taking into account their years of service, then yes, university has all the right to give that leeway. But in essence, the university has the right to claim for all the monies that they have spent on you during your study period.
Okay, thank you, Mr. Etchi. So do you have any other questions before we close the floor? Okay, you can. Tak ada, no other questions, yeah? All right, if that's the case, thank you so much
Sorry.
for having, okay, brother, Bilaku.
Yes, I'm Shakur from COM. I would like to ask one question regarding if a student or candidate fail to complete the program, either due to fail the examination, and even after extension, do they have to pay back all the salaries and also fees that they have been provided for the program?
Yes. Yes. Whatever the agreement clearly says that if there's a breach, in the sense that you cannot complete your course within the period granted by the university, that is considered as a breach, and the university has the right to claim whatever they have expended on you during the course period, including the extension period. So whatever that you have taken from the university during your course period, you are supposed to return it. So that's why I said the concept of putting the university back in its position before the agreement. So yes, to answer your question, yes, you have to pay back everything.
Okay, so I'm asking this because comparing to KKM policies, so even if they are failed due to failing the exam, and not because they stop the study or they immaturely stop the program, they are not eligible to pay. They are still allowed to continue to work, and they still receive salary, and they don't need to pay the amount that the KKM spend on them. So, so that's why I'm asking, because it seems that because the amount is a lot, and for investment, I think yes, we as a student, we receive privilege, but as a company, I think you also invest on us. So for investment, also there is a risk of loss lah. So I think it's like in kita University Islam kan, but it's like the payment to a lot, and then also it's like macam kesian lah, because some of them is fail because of the exam. They cannot pass the exam somehow. Maybe the program supervisor or the examiner don't think he or she cannot complete the program, and they fail the program. Not because of they didn't want to complete the program. It's just that they're unfortunate and cannot complete the program. So how is there any leeway on that? Because in KKM they are not have to pay everything, and they're still allowed to work.
Agreements will differ from parties to parties. See what you have signed, those students have signed with KKM. We won't know. We are not privileged to their agreement. Their agreement probably saying that okay, in certain circumstances, this would consider breach. If you fail your exam because of these reasons, this doesn't constitute a breach. probably they have that kind of agreement. We really don't know. I have not seen any agreements with KKM. But like what Mr. Rao said earlier, the first time around, the intention of parties when they are signing the agreement, that is important. So if the intention of KKM is that only if you comply, you just have to comply with ABC. If you cannot complete your studies because you fail your exam or you have problem with your supervisor, I can give you leeway. Then it's up to that candidate and KKM. So that would be their intention as far as their agreement is concerned. But as far as IMM is concerned, we need a qualified person to come back and serve us.
Joman, I think that is what has, in a nutshell, that you have asked us today is that the compensation is too high. That it will be a mountainous burden on you should there be a breach. Now, reverting to what we have said earlier, this is a contract by law undertaken by two entities who have gone in with a free will nature to engage. So again, with the greatest respect, it is no operation, there is no suppression, no one has forced one party to engage into this contract. So that is the reason why court will say that when we enter into the contract, we know with our eyes open the consequences of what I'm getting into. Now, halfway through, like what Professor had indicated earlier, that there are difficulties with any other issues that you are unable to see through. Have a dialogue, come back and say, listen, I don't think so, I can, before it becomes even more difficult at a later stage. There are ways out of it if you want to. But if your consideration is that, listen, that particular organization is not asking too much, but we are. Conversely, I could also say that it was all already in the four walls of the contract, where the court will look into it with the greatest respect. So these are the things that you have to really consider before even embarking on this. Or if in the event that there are already doubts creeping in your mind that, listen, I am going to have problems, I can't come out of it. Maybe there is room for you to calm down and maybe discuss and have a dialogue and see where this matter can be resolved amicably. That would be a better option. But coming back to that question, the hard question that you asked, can I get away with a lesser sum? Unfortunately, the answer will not be no. That's how it is. It is my contract, unfortunately. So we are bound by that, and the university will claim what it has expended for that one candidate. Like I told you earlier, because that position that they have taken has deprived another potential candidate who could have gone to it. So that is the principle of it, unfortunately. Yeah. Also, hopefully that would give some idea of compensatory reliefs, which is mandated by the university, unfortunately. Thank you.
Okay, thank you so much, Mr. Rao. And thank you also, Dr. Bishaku. I think that's all questions we have today. All right, so I guess we have come to the end of our session. So brothers and sisters, we record our deepest appreciation to all the attendees and also to our distinguished speakers, Mr. Jayananda Rao and Ms. Gayatri Chandravasan. And now I invite Dr. Prof. Abah Faris bin Ismail, accompanied by Mulia Encik Raja, to present the token of appreciation.
Oh, yeah. Thank you very much. Thank you.
All right. But nevertheless, I think still everybody is here. I think the one good thing that Mr. Rao has mentioned is, if you have any doubt, any query, any question, then come and ask. That's the most important thing. Don't assume, anything. I mean, like for example, the question of where or when do I have to report for duty, or I have this problem, what should I do? I think come and ask. I think we are here to
I mean,
assist. Yeah.
from what, taking from what Prof said, that I think that we have been doing IIUM work
Yeah.
for the past 13 years. I have not come across an entity which is more prihatin. I would say that, definitely I would say that. I would say that compared to other clients that we have, that is a dog work. Just go and get it, go for the jugular. But here, no. We have gone through negotiations. I think Yang Mulia Raja Badrul will agree, the legal department, Chair Haikal will agree, that the time given to resolve the issue, the compensations, that time period can go beyond a lengthy period. I think that there is always room to negotiate, not negotiate, to discuss, like what Professor Whiteley said. I think that that is also something to really to admire as far as IIUM is concerned.
Okay, thank you. So we have some.
Thank you, sir.
This from the legal people. I'm not sure. I don't know what they're giving you.
Thank you. Thank you very much. Thank you very much. Thank you very much for everything. Thank you.
Baik sekali.
You can.
Thank you, sir. Thank you very much. Thank you very much for having us again. Thank you. Thank you.
All right, thank you.
Thank you so much, everyone. Thank you, Dr. Prof. Thank you, Mr. Ralph. The next part will be to invite everyone for a photo taking session. If everyone who is available to switch on their cameras,
How you going to do it?
just screenshot.
I can.
Panjang financial tadi. Panjang financial.
Oh, put everybody. Okay, all right. We are there. We are there in the room there.
Okay, everyone.
Hello, everybody.
Right. Since I think there's a lot of us, we'll do it by stages, eh?
3 pages.
All right. So the first page. Right. Siapa yang buka kamera first page juga. Alright. Ready? Okay, 3, 2, 1. Alright. Next page. Tadi buka. Okay, tak apalah. The first page je. Okay, thank you so much everyone. Thank you so much.
Thank you. Thank you very much, everybody. Have a very good day. Thank you very much.
Thank you again everyone for your attendance. It will be beneficial for everyone. And just housekeeping, remember to fill in your I-10 and to fill in the evaluation form. And inshallah, hopefully we have more programs like this. And as stated by Dr. Prof, you can just reach out to the secretary at any time. We'll be happy to help. Subhanallah wa bihamdika asyhadu an la ilaha illa anta subhanaka inni kuntu minaz zalimin. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. Thank you.